Okay, good morning, everyone. I think we can begin our webinar. Thank you very much for joining us today for 3PB's Family Law Brunch. We have myself, Rachel Bale, and Ms. Laura Scott presenting today. Questions will be answered at the end of this talk, so please could you post any questions that you have in the Q&A function, and we will attempt to answer as many as possible at the end. We will also be sending out our PowerPoint presentations to you at the end of the webinar as well, so if anything gets missed, you have the chance to review it then. So without further ado, I'd like to introduce Laura Scott. She is a leading junior barrister who joined 3PB in September 2022 last year, after practicing at a different London chambers for over 20 years. Laura has been a children law specialist for most of her time at the bar, and her practice now focuses primarily on serious public law matters, including non-accidental injuries and abuse in all forms. So without further ado, I'll present Miss Laura Scott.
Thanks very much, Rachel. Morning, everybody. So today I am going to be talking to you about CCE, which is Child Criminal Exploitation, and county lines. And I've called this a whistle-stop tour because there's a huge amount of information to try and pack in. And the reason that I've chosen to talk about this today is because I have noticed a huge increase over the last year or two of the number of teenagers that are becoming subjects of care order applications. So I'm doing this talk not from any great place of expertise, but from a position of real curiosity to find out more about this huge issue. And it seems to be something that is, from what I can gather, a quite underrepresented crisis that is happening within society. So what we're going to be covering today are some basic definitions. We'll be looking at different aspects of CCE, including the county lines model, considering some of the safeguarding aspects, and also looking briefly at some of the risk factors for children, young people, and vulnerable adults. What we're not going to be dealing with today is child sexual exploitation, apart from just simply touching on that in a couple of places. We won't be looking at accommodating young people because this is such a huge area in itself, or looking at any deprivation of liberty matters. So turning to the definitions of CCE, this is one that comes from the Home Office. Child exploitation is when someone uses a child for financial gain, sexual gratification, labour, or personal advantage. It includes using cruel or violent treatment to force a child to take part in criminal or sexual activities, and often leads to physical and emotional harm to the child, to the detriment of their physical and mental health, education, and moral or social development. And this exploitation can take a number of different forms. Perpetrators may subject children and young people to multiple forms of abuse at the same time, such as criminal exploitation, including county lines, and sexual exploitation. And then we have another Home Office definition from some of the county lines guidance from 2018. CC is common in county lines and occurs where an individual or group takes advantage of an imbalance of power to coerce, control, manipulate, or deceive a child or young person under the age of 18. The victim may have been criminally exploited, even if the activity appears consensual. It doesn't always involve physical contact. It can occur through the use of technology, and we'll be looking at that in a bit more detail shortly. Another definition of CCE here from the NSPCC, it's child abuse, where children and young people are manipulated and coerced into committing crimes. And then we have a further definition here. And this has come from an all-party parliamentary group on child criminal exploitation and knife crime, which was held just a couple of months ago. And they are recommending that a broader definition of CCE should be given, and that should be guided by the young people themselves, who have described it in their own words quite powerfully as when someone you trust makes you commit a crime for their benefit. So we have an issue here in that there is no statutory definition of CCE, and that, in my view, causes some difficulties, firstly with clearly identifying when children, or potentially their parents, if they're vulnerable, may be involved in CCE, and it also causes difficulties in terms of how to gather information about that potentially happening. So there is some law on it. We have the Modern Slavery Act from 2015, and that creates the offence of slavery, servitude, and forced or compulsory labour. I'm not going to read out all of those statutory provisions, and of course you'll have access to the slides following this talk. But you can see there that it does create that offence. So there is means of prosecuting people who are found to have perpetrated this type of abuse. We also have now the national referral mechanism. Now, this is a framework for identifying and referring potential victims of modern slavery and ensuring they receive the appropriate support. Often this is considered to perhaps not apply to children and young people that are caught up in CCE, there being the misconception that this is something that's only available for victims of trafficking, for example. But this is absolutely a route that should be used if there are concerns about children and young people. And one difference is that if you are looking at making a referral because you're from one of the specified professional bodies that is able to, such as police and local authorities, if you're referring an adult, you have to have their consent to do that. If you're referring a child, you don't need to obtain their consent to make that referral. Looking at the scale of this issue, around 22,000 children were referred to the NRM to the year ending 2021, and yet there are only 185 successful modern slavery-related prosecutions. And of course, that's only the children that were actually referred. So we can infer from that that there are much greater numbers of children that are caught up in this that are completely off the radar. And before moving on, I should say as well that the other legal aspects that we can employ where this is an issue is Section 31 of the Children Act. And of course, that is what we'll be most familiar with seeing coming into play when dealing with children, because they tend to be considered to be beyond parental control. And that's certainly the mechanism by which they're being brought into proceedings, as opposed to there being any other clear concerns about suffering harm as a consequence of the parenting that they're receiving. So moving on now to look at the county lines model specifically, this is a term used to describe gangs and organised criminal networks involved in exporting illegal drugs into one or more importing areas within the UK using dedicated mobile phone lines or other forms of deal line. They are likely to exploit children and vulnerable adults to move and store these drugs and money, and they will often use coercion, intimidation, violence, including sexual violence, and weapons. So this is a rather shocking image. This is a map of the various county lines drug supply routes across the UK. And you can see that there are three main centres here which we're going to touch on shortly, which are Merseyside, the West Midlands, and London, Greater London. So the scale of this is quite extraordinary. County Lines is financially motivated, and that's the NCA's definition. There are approximately 1,000 different lines operating nationally. As I've said, the majority are originating London, West Midlands and Merseyside. And it's thought that the profits from each of these lines are around £800,000 a year, making an overall profit of £800 million each year. So this is a really big business. Looking at the County Lines models, you'll see the top part of this diagram is what we would consider to be the traditional model, where from one of those, let's say those three main exporting areas, children are recruited and sent out, often by train, or certainly it used to be mainly by train, to an importing area. So they'd be sent off on their own with a bag and told to go and meet a person at a place quite some way away from where they live. Now, this has evolved somewhat over the years because of various disruptions to the model. So now, because there is a little bit more scrutiny and policing of the transport networks, there's a bit more awareness that this traditional model was being used. What's happening now is that the children are being recruited from the importing areas, and perhaps making shorter journeys and what have you, so that they can evade detection. Why is County Lines such big business? Well, it's driven by the demand for heroin and crack cocaine. And the number of users of those drugs has risen steadily over the past 15 years. There's also seemed to be an increase in crack use outside of urban areas, and that is also driven by the use of aggressive marketing. Who and how is County Lines working the way that it is? Well, it can involve any child of any gender and, importantly, of any social background. It can also include any vulnerable adult. It can appear to be consensual. The people, young people, children involved may appear to be wanting to do what they are doing. It can involve force and/or enticement. It is often accompanied by violence or threats of violence. And it can be perpetrated by individuals or groups, males, females, young people, or adults. And it is typified by some sort of power imbalance. And I think this point about it being potentially affecting any child is really important to note. It's not just the children who may already be on the local authorities' radar, for example. It can include children whose parents are professionals, whose parents undertake shift work. And there was a news article just this morning, actually, of just 1,000 children that seem to be missing from education. Nobody really knows what's happened to them. So children that are outside of education are especially vulnerable, as are children that are within the care system, especially if they've been removed from their homes. How else does County Lines operate? Sorry, before we move on to that, just looking at why it is that children are particularly vulnerable here. They're easy to manipulate and control. They're not deemed to be out of place in town. So if a child does turn up in a different town, there's not going to be perhaps the same scrutiny of them as there would be of adults that aren't familiar to the community, children are cheap and they're easy to bully. They're very difficult to prosecute. They appear innocent because largely they are innocent. And they're very vulnerable to threats to their family. So how does the county lines model recruit these children and young people? Well, the internet is a huge part of it, increasingly so, and social media is frequently used to identify victims and then to initiate contact with them. They can also be approached in chat rooms, including within games online. And the internet is used to maintain contact with the victims, and it's used as a means of exerting control over them. For example, it can check their location. So the unguarded use of mobile phones by young people is a really huge problem. So any unfettered internet access leaves children vulnerable. Another method is for the people, children, young people, to be approached within the community, perhaps by an adult or another child. They may be offered money or goods or drugs, and then they're pressured into committing criminal activity. That might include carrying drugs or causing violence to somebody else, or perhaps holding drugs within their home. And then they become trapped into the system and can end up working their way up the hierarchy. So one of the means of online contact with potential victims is by professional seeming adverts targeting them, offering them money, clothes, trainers perhaps. And then once the victim engages and receives that particular benefit that they've been offered, they're then forced to pay that debt back by carrying the drugs or doing whatever activity is required of them. And they're tracked by their phone to make sure that they do what they've been told to do and go where they are supposed to. And if they turn off the phone or they turn off the location tracking, they are then threatened or subjected to violence. And a really important aspect of this is not just violence to them, but threats of violence to their family. And of course, social media allows that to happen because it's so easy to build the child's network around them. You can see who perhaps their parent is, go onto their parents' social media, see who the broader family is, see pictures of younger siblings, work out where the younger siblings go to school and so on. So one aspect of the county lines and CCE model generally is cuckooing. And this is where the person, maybe a vulnerable adult or sometimes a child or young person, is exploited by their home being used. They're threatened with violence, or they're paid in drugs, or they build up a drug debt, and their home will be used by dealers essentially as and when they want. And obviously, it goes without saying, really, that children that are within those cuckooed properties have an increased risk themselves of being groomed. And I think for anybody that's really interested in finding out in more depth about this, it might sound an unusual recommendation, but I would highly recommend watching the Top Boy series. I think it's still on Netflix, but that really captures just the scale of this issue, and also how it impacts on the young people and how they become so trapped into the system. So what guidance is there? Where do we look to for some help with this issue? Well, the Child Exploitation Disruption Toolkit is a really excellent place to start. If you just Google that, you will find it. It's a government toolkit essentially, and that really sets out in comprehensive terms what exploitation is, how to really understand the problem in a local area. And of course, collaboration and working together are crucial for that. Working together, of course, to safeguard children has also evolved over the years, and that is now starting to address this particular issue in a bit more detail. And agencies are really encouraged to think outside the box, essentially, into looking at underutilized sources of information. So going out into the community to find out what is going on for these young people. The Disruption Toolkit sets out very helpfully all of the different proactive and reactive actions that can be taken, the proactive orders and mechanisms by which suspects and offenders can be curtailed in their access to young people are certainly underused in my experience. And there's also a number of measures that can be used to help support victims. So I've just mentioned working together. And we're used, aren't we, to the traditional model of looking at safeguarding in terms of what are the conditions within the home that can cause harm or are pushing a child or young person into antisocial behaviours or offending. And there's a move towards what's considered to be contextual safeguarding. So that's not just looking at the factors that are pushing children out of the home, but looking at what is pulling them as well, as I've already mentioned, offers of clothes, money, perhaps protection. And part of that, of course, is the need to know what these young people are engaging with online as well. What is going on at school? What is going on in the neighbourhood? So I've set out paragraph 40 from Working Together, and that just explains in a little more detail what we've been talking about this morning, but it's a small part of a very, very big document and perhaps needs to go a little bit further now that this issue is clearly not going away and is growing, because they talk in that document about extremist groups making use of the internet to radicalise and recruit. And of course, it's not limited to that. That is very much what is used to recruit children to CCE. So I'm just going to go through very briefly some of the vulnerabilities and particular risk factors for potential victims. Got that lovely quote from Gabor Mate there about trauma. What we would once upon a time have considered to be trauma, these objectively life-changing events, is known now to not really be the right definition of it. And trauma is, as well as being an effect of being a victim of CCE, it can also make the young people, children, more vulnerable to being exploited. And I'm sure anybody that's practicing in care proceedings will have seen that there's now far more recognition of the impact of childhood trauma on particularly parents within the child protection system. So we have there some aspects of trauma and how they can make people more vulnerable. Similarly, adverse childhood experiences increase vulnerability. I've set out some of the main ones there, but I would add to this a caveat that whilst the ACE model is now very widely used, it's not without its controversy. And there is some concern that it can be a bit too rigid, and that can lead to assumptions about how people's lives are going to pan out if they've experienced any of these aspects. And of course, if these aspects are not present, it doesn't mean that the person is not at risk. The dynamics of adolescence also make children really vulnerable. The additional adrenaline, the peer group, peer pressure, and the draw towards short-term gains. Desensitization, also a huge factor, makes it far easier for children to do things that they wouldn't ordinarily do, because sadly what they're exposed to online and in the world around them, it is so shocking that the step into that happening in real life is not as large as it might once have been. So to finish up, I just wanted to pop a couple of provocations out there for you to think about. One is the Children Act 1989 still fit for purpose in 2023? And the second one is, are we as professionals contributing to this CCE crisis by ourselves becoming desensitized in thinking that there's nothing that can be done for children involved in CCE? So finally, I just wanted to give my thanks to Andy Thompson at CYP First, who freely gave his time to me for me to ask him a number of questions about this aspect. Andy works with victims of criminal and sexual exploitation. He really is an expert in it, and I give my sincere thanks to him. So thank you all very much for listening to me. I am going to hand over now to Rachel for her part of the webinar. Rachel is a junior barrister joining 3PB as a tenant in October 2022. She has a diverse practice specialising in financial remedy, TOOLKIT disputes, and property and chancery work. With Rachel's acute knowledge of property and chancery matters, she's able to cross-advise on technical legal matters involving large estates, property management, and inheritance claims alongside traditional financial remedy matters. Rachel regularly represents husbands and wives in final hearings, FDRs, and first appointments, and has been successful in complex cases involving issues of capacity, setting aside on the basis of material non-disclosure, and conduct. She is also well placed to advise couples on prenuptial and cohabitation agreements, which is, as we know, a growing trend. So I'm now going to hand over to Rachel and try and stop sharing my screen.
Thank you very much, Laura. A really fascinating talk. And we're shifting gears a little bit here with regards to financial remedies, if I can share my slides. So I hope everybody can see this. We're going to be discussing today, or I'm going to be discussing today, setting aside financial remedy orders. In the agenda, firstly, what are the situations where you may want to set aside and where may you want to appeal? What are the applicable grounds, the procedure required, any practical realities that may come up in such an application, and of course cost implications of setting aside. So when can a party set aside a financial remedy order? So this is, imagine a situation where you've gone through your first appointment, you've gone through your FDR, you've come up with a really happy consent order, or perhaps a final order from the courts. And then a few weeks, perhaps some months, if you're unlucky like me, on the exact day that the order was drawn up, your client comes to you and says, something has now come to light, I'm not happy and I don't want to be bound by these terms. What do you do? There are two real choices here. One, you may want to appeal, and one you may want to set aside. And the distinguishing factor here is you should only really be appealing, or you can only really appeal where the court has made an error. That may be a contradictory finding in law or in fact, or perhaps it's a situation where they've overlooked something. A key example would be capacity, for example. Capacity issue has been risen, and therefore it may be basis to appeal the order. Now, appeal routes are set up through part 30 of the family procedural rules. I'm not going to go through it in this seminar, but just to show that distinguishing factor there. Setting aside is more often used where the error or fault or new circumstance arises between the parties, or on behalf of one of the parties, and therefore that materially invalidates the substance of the order, and that is a phrase that we will continue to return to throughout this seminar. A word on consent orders, of course, these are express agreements between the parties, and thereby will have to be go through the set aside process. They don't have the option of appealing in that normal way. And of course, setting aside can apply to rose orders as well as binding terms. Just before we start, that setting aside in general is a high bar. The court will not set aside an order lightly, and in the back of their mind they will always have this idea of the finality of litigation, the fact that parties have come to an agreement or a conclusion has been reached, and thereby it is a high bar to suggest that the order should be set aside. The court's power I've just set out there for clarity. We have the Matrimonial Family Proceedings Act 1984 that sets out kind of the wide power that the family court does have to vary, suspend, rescind or revive any order, and of course the key point there is it can be in part or in full. It doesn't have to necessarily set aside the entirety of the order. However, I suppose that the most important statutory provision is the Family Procedural Rules 9.9a, and that practice direction as well really sets out the procedure that will need to be followed as such. Okay, the grounds for setting aside. Now, Practice Direction 9.9a, paragraph 13.5 really does set out the key grounds that one can rely on for a setting aside, but it also makes quite an interesting point here. The grounds on which a financial remedy order may be set aside are and will remain a matter for decisions by judges. Now this, I wanted to draw attention to this because I'm comparing this with Judge Moyston's dicta in CB and EB, a 2020 case, where he actually states the language of 13.5 is misleading and it should not be read literally. There is no lawful scope for imaginative judges to unearth yet further set aside grounds. The available grounds, the traditional grounds, no more, no less. So 13.5 does set out the four grounds that can be relied upon, and I suppose the court's making it quite clear here we're not looking to expand these, which again goes to the point of it's a high bar and will not be done lightly. So the first ground then, I've amalgamated two together because they are quite similar: fraud, mistake and or material non-disclosure. I'd say that's probably by far the most common application for a set aside, or sorry, the most common ground I should say for set aside applications. Non-disclosure is a key one where, for example, one party states that the other party has not raised something, not disclosed something, and later found out that would materially change their decision. I have a few examples of where this has survived as a ground and where it has not. So Livesey and Jenkins is a key case, House of Lords 1985, and this really set the bar that only disclosures which would have made a substantial difference to the order will apply. Not every non-disclosure is important enough or would have gone to the heart of the order in any event. So an example of this, a case called Vickery and Vickery, it's a 1992 Court of Appeal case. This is where husband and wife made a consent order on the basis that the husband had £430,000 in shares in his private company. Husband had failed to disclose during these negotiations, during the FDR process, that negotiations were taking place on behalf of his company to sell his company. And very shortly after the order was drawn up, his company was sold for £2.8 million. The court decided that it was right to set aside this order on the basis that that was quite a material non-disclosure which would have affected. However, compare this to the case of HP and AP, which is a 2023 case, very recent. Now, this was on the basis that the husband failed to disclose two loans which were secured against his property made 20 years ago. Now, these had been settled with his father. His father ended up owning 100% of the property. And it was deemed to be a non-disclosure. However, it did not materially shift the territory on which the dispute sat, so the order was not set aside. And curiously, the court here did also apply the point of duty on the court to manage proceedings and limit disclosure to that which is required. So if we're looking at previous documentation and prehistoric issues, it is not necessarily going to be appropriate. Kingdon and Kingdon, the third bullet point there, is an interesting case. This is a 2010 Court of Appeal case. Again, husband failed to disclose purchase shares in a new company. I'm sensing a bit of a pattern here with these types of cases. However, in this case, the court decided it wasn't necessary to dismantle the order and set it aside per se, but simply to add to it and to add the missing or non-disclosed assets, which I suppose goes to the point of their wide discretion that the court has and the flexibility that they can apply with such applications. A clear case of fraud was the case of Sharland and Sharland. Lady Hale gave the dicta here in a Supreme Court case. This again was where the husband did not disclose plans for his company to go public, and was deemed to be a material fraud in this case. And Lady Hale states it would be extraordinary if the victim of a fraudulent misrepresentation, which had led her to compromise a claim in matrimonial proceedings, were in a worse position than that of a victim of a fraudulent misrepresentation in an ordinary contract case. So I suppose it's the general principle of fraud will unravel all, but with a slight caveat that in fraud cases, the burden does shift onto the fraudster, and they have to prove that the particular fraud did not vitiate consent, and that had wife known of the concealed facts, it would not have substantially changed the order in any event, and in which case fraud will not succeed. But again, it's a very high bar, and that burden shifting makes it quite difficult for the fraudster to prove that. Mistake is a less common ground to rely upon. This arises where the applicant shows at the time of making the original order, either they and or both parties made a mistake as to the assets or to the circumstances, not their fault and not something that could have been established prior, and that would change the outcome of the order. But it is quite rare for that to arise. Second ground, I'd say fairly common, is a supervening event, and this is quite common in the case of death. Now, the key leading principle is the case of Barder and Kalawori on this, which is a 1988 House of Lords case. This was quite sad facts in this particular circumstance. The husband was agreed to an order to transfer his interest in the family matrimonial home over to wife, as she was the primary carer for their children. 5 months after the order was made, wife subsequently killed herself and her children, and the husband brought a claim to attempted to set aside the order on the basis that the factual basis of why the consent order had been agreed had disappeared. Now, the Barder event sets up some quite strict limits. It will not be used in all situations, and I have provided a little analogy which helps me to remember the 4 criteria. I use a PINT criteria. So P stands for promptness, so there must be promptness of the application. The courts will not look favourably if an event arises, say a month after the order has been made, yet the application does not go in for another 6 months. It must be prompt, and there must be good reasons if there is no such promptness. I stands for invalidation. Again, it's this idea that the event has had to have invalidated the basis or the fundamental assumptions between the parties as to why the order was made in the first place. It has to touch the heart of the order. N goes to there should be no prejudice to third parties who required in good faith some sort of consideration out of the order. It would be deemed unfair if third parties were affected by such set aside. And fourthly, timing. The timing of the event has to be reasonably quick after the order was made. Now, of course, how long is a piece of string on that point? What is reasonably quick? We can see in Barder 5 months was deemed sufficiently quick enough an event to take place. There are cases as late as a year, but I would suggest that's probably at the upper limit of what the court would award in such timing. And of course, it will always be fact sensitive on the basis of what's of the relevant circumstances. So just giving some examples of what a supervening event is then. So death, it isn't as simple as Barder where one party dies, so it will necessarily invalidate. A case where it did is a case in Amy and Amy 1992. This is where the parties made an agreement, and they always intended for it to be improved as a consent order, but before it got to approval, the wife died, and the husband simply said, well, she's now gone, surely the term should not be abided by. The court denied this, stating that there was a fair distribution of the asset and that death had not undermined the assumptions. However, comparing this with the case of Barbara and Barber, which is a 1993 case, this was a case where the wife was actually sick and she was given a prognosis of 5 years to live. And the agreement was made on the basis that she should receive more than 50% in the event that she did live 5 years. However, she did die 3 months after the order was made. And it was suggested in this particular case, the order should be set aside as it had invalidated the fundamental basis. Some other potential supervening events, where there has been a dispute to the value of assets and it has substantially changed, that may also cross over with non-disclosure, of course, but if it's deemed to be such a big change, it may sometimes stand as a barter event. Remarriage and cohabitation, however, again, it has to affect the party's entitlement to capital for that to stand. Something that will not be classed as a barter event will be changes in the law. So there's a case of S&S where wife suggested that she had agreed a lump sum on a clean break basis 1 month before the landmark decision of White and White came, and she tried to apply on that basis that change in the law had substantially changed her assumptions of what she should get. The courts were quite clear. Changes in law are not unforeseeable. It's actually quite a foreseeable situation, and therefore it will not work to rely on that as a barter event. Similarly, kind of economic fluctuations, so ideas such as the credit crunch or perhaps cost of living crisis. There is a Court of Appeal case in Meyerson where the husband was ordered to pay £25 million when his company shares were at £2.99. By the time his first payment was made to wife, his shares were down to 27.5 pence, so a significant drop. And the court made the decision there that whilst it did have wide-reaching consequences, economic fluctuations would not constitute a supervening event. Finally, there is the ground of undue influence. This shows that there has to be significant pressure or duress which vitiates consent. It can't simply be that one party is perhaps a stronger in force over the other and emotionally perhaps putting pressure on them. It really has to be significant, and it is a standalone equitable principle of its own right, undue influence. A high bar again, and again it will go down to the sensitive question of fact and examination between the parties. I suppose there has been developments in conduct issues with regards to economic control, coercive control, and those types of situations may give rise to an undue influence argument, but it would have to be significant. Procedure then for setting aside. So as I set out before, Practice Direction 9A is very, very helpful in setting out what to do and when to do it, and also Part 18. This is technically classed as an interim application, so Part 18 sets out the formalities. It'd be very rare to be making an order, making a set-aside application for an order made prior to April 2014, so it's normally going to be to the court that made the order. That's who you apply back to. And the form will be simply a D11 application notice with a written statement in support and a draft order attached as well. Please take note of paragraph 13.8, however, of Practice Direction 9A. You must set out the ground that you're relying on, or grounds if there are multiple. That would be strange, but that could happen. A mere allegation of non-disclosure, for example, will not be sufficient, and the court is quite hot on that you need to fully set out what you say the grounds are for setting aside. Also, interestingly, that the level of judge will be the same, but they also try, where reasonably practicable, although it's often not the case, to put the application in front of the same judge that dealt with the original order. I suppose that makes sense with regards to they know all the background facts of the case, and they're probably in the best position to see whether this supervening event, for example, or non-disclosure actually makes a material difference, having seen the parties at the time. Practical realities, then, I'm just checking on time. So there may be disclosure issues. This is typically if you are instructed perhaps after the order is made, perhaps a consent order between non-represented parties, and you're finding it difficult to get disclosure of what was said or who said what at the time, or what hasn't been disclosed. The best you have to have best endeavours with the other side and trying to get the disclosure, and also asking the court for any relevant information that they may have. If absolutely necessary, there is of course the way of third-party disclosure orders that's set out by FPR 21.2, and that can be if a third party has disclosure that is needed, particularly for non-material disclosure issues. An application can be made for the court to compel them to provide that. Again, this promptness of the application, it must be made promptly, and I suppose if you are having issues with disclosure, you should be being proactive and also recording if you're coming up with difficulties in getting it, and that can go into your application as to why perhaps it's a little bit later than you would have liked it to be. Also, what is the outcome of a set aside? I mean, there's different. The court has wide discretion, so the court can give directions for a full rehearing to take place, and to redetermine the original application if it's deemed sufficient. However, normally it may be that it has sufficient information to redetermine the original application at the same time of setting aside, especially if a full day has been permitted, for example, for the application. Even if there is a rehearing, it doesn't necessarily mean that we have to go right back to the beginning and start again. It is possible for the court to isolate the issue of, for example, non-disclosure on one particular point, or misrepresentation, and deal with that sole issue in setting aside the application. You may also want to anticipate the respondent's response to this. The respondent may, especially if at any time has passed, make an application for notice to show cause, in that your client should be held to the terms of the agreement, and they may do that because of course then it brings in the cost implications as well, and you just may want to, it's sometimes known as a dean summons, but that is normally a tactic used by the other side. So cost implications then, of course, any application for setting aside falls outside of the normal procedure of no order to costs, and that's explicitly set out in 28.39, and so thereby the clean sheet approach will be the starting point. Of course, as Solomon & Solomon says, this can be more easily displaced than would be in civil proceedings, and the courts will look at CPR rules in order to deal with costs. Another point to retain, of course, is that there is admissibility of colder bank offers or other offers in this situation, so that is quite a handy point if any offers have been put on the table for this. Now, the court will draw upon CPR 44.2 and 44.3 in particular, looking at proportionality, and on the next slide there is the routes that they'll look at there. So for example, the sums in issue, the value of any non-monetary relief, and the complexity of litigation. A word of caution on costs: any kind of trivial applications will attract severe cost implications, one should make their best endeavours to keep costs reasonable. I recently had a case for this where costs had reached 16,000 for a set-aside application. We were successful, but the judge reduced it down to £2,000, suggesting that the other side was unrepresented, but suggesting that it was deeply disproportionate in terms of grade A's being used and the amount of time spent on it. So a word of caution to bear in mind, especially 44.3. And of course there are two different bases for costs that the court will normally apply it on the standard basis, which means it will be proportionate and reasonable costs allowed. Any disproportionate costs will be disallowed for that. However, indemnity basis can be applied also, where there will be no focus on proportionality, and any doubts of unreasonableness will go to the receiving party rather than the paying party, and this is used to show a little bit of court's displeasure and perhaps the amount of time spent or the grounds on which the application.
Next month, and thank you all so much for joining us today.
Thank you. Goodbye.